A young lawyer faces jail in a federal courtroom, but what she pulls from her briefcase stuns the judge, silences the critics, and rewrites constitutional law in a heart-pounding clash of courage and intellect. The federal district courtroom was a cauldron of tension, its oak-paneled walls and high ceilings amplifying the drama unfolding within. Judge Anthony Terenga, a towering figure at 62, stood imposingly in his black robes, his piercing gaze locked on Karoline Leavitt from the elevated bench. Known for his razor-sharp temperament and ironclad devotion to courtroom protocol, Terenga was a jurist who brooked no defiance. Moments ago, his voice had sliced through the charged silence, delivering a bombshell that sent shockwaves through the packed gallery. "Ms. Leavitt," he declared, each word a gavel strike. "Your persistent refusal to comply with this court's discovery order is direct contempt. I am prepared to order you into custody if you do not produce the requested documents by noon tomorrow." The press corps gasped, a collective intake of breath that rippled through the room like wildfire. Karoline Leavitt, just 28, stood resolute at the defendant's table, her tailored navy suit a stark contrast to the chaos erupting around her. The former White House communications official, now chief spokesperson for the conservative Liberty Foundation, maintained a composure that belied the storm within. Whispers buzzed among the spectators, journalists, legal scholars, and political operatives, stunned by the judge's extraordinary threat of imprisonment in what had begun as a routine civil case over government transparency. Terenga's frustration had been palpable earlier, his glasses removed as he pinched the bridge of his nose, declaring, "Your client's position is untenable, bordering on obstruction." Yet Leavitt, a Harvard law graduate and rising star in conservative circles, betrayed no fear. Behind her calm facade, her mind raced, sifting through legal precedents and constitutional principles, knowing this moment could define her career or destroy it. What Judge Terenga didn't know, as cameras captured every heartbeat and reporters typed furiously, was that Leavitt had come armed with a legal maneuver so audacious, so meticulously crafted, it would turn this confrontation on its head. As she reached for her briefcase with deliberate calm, the room held its breath. What she pulled out next would leave the courtroom in stunned silence, render the judge speechless, and spark a seismic shift in the understanding of executive privilege in American jurisprudence. This wasn't just a legal skirmish, it was a battle for constitutional clarity, a clash that would echo through courtrooms and law schools for years to come. Before we unveil the electrifying twist that changed everything, smash that like button and subscribe for more pulse-pounding political and social analysis. Now, let's dive into the saga of how Karoline Leavitt faced down a federal judge and reshaped the law. The stage was set for a showdown that transcended the courtroom, probing the very foundations of separation of powers and judicial authority. To grasp its stakes, we must first meet the titans at its heart, Judge Anthony Terenga, a legal titan whose rulings shaped the District of Columbia's federal bench, and Karoline Leavitt, a young lawyer whose meteoric rise defied her age. Their collision wasn't just personal, it was a crucible for constitutional principles, a test of courage against power. Anthony Terenga was no ordinary judge. Appointed by President Obama in 2011, he'd forged a formidable reputation over decades, his Yale and Stanford law degrees complemented by a career as a federal prosecutor targeting government corruption. At 62, with salt and pepper hair and eyes that pierced through pretense, he commanded his courtroom with an authority that inspired both respect and trepidation. His rulings, rarely overturned, reflected a deep commitment to government transparency and a skepticism of executive overreach, earning him praise Finley social circles. Law clerks whispered of his ambitions for the D.C. Circuit Court of Appeals, and his handling of high-profile cases, like this one, drew the scrutiny that could elevate or derail his legal legacy. Yet Tanga's public neutrality masked a fierce intolerance for what he saw as delay tactics, making him a daunting adversary. Before him stood Karoline Leavitt, a figure who embodied the law's next generation of legal warriors. At just 28, she'd already carved out a path through the highest echelons of conservative politics, serving as an assistant press secretary in the Trump White House, and later becoming New Hampshire's youngest congressional spokesperson. Now, as the Liberty Foundation's chief communications officer, she was a poised advocate for constitutional originalism, her Harvard law honors earned through sheer grit from a humble middle-class upbringing in New Hampshire. Where Tenga was methodical and traditional, Leavitt was dynamic, blending rigorous legal rigor with modern media savviness. Her calm under pressure made her a go-to for combative TV interviews, but this courtroom clash tested even her formidable steel. Her poised exterior masked a mind racing with strategy, her every move calculated to protect not just her client, but the constitutional principles she held inviolate. The case itself had ignited from humble origins, but exploded with colossal implications. The Liberty Foundation had launched a lawsuit to challenge a new federal agency's regulatory authority, sparking a discovery dispute when government attorneys demanded all communications between the foundation and former White House officials. Leavitt refused to produce certain documents, citing a bold, novel interpretation of executive privilege that extended to former officials consulting on related policies. Tenga, viewing this refusal as stonewalling, had grown increasingly exasperated, his patience eroding until it culminated in his dramatic threat of jail time. The stakes were nothing short of staggering. Leavitt's personal freedom, her professional reputation, and a potential legal precedent that could redefine the boundaries of executive privilege for future administrations. Constitutional scholars buzzed with debate, law schools planned symposia to dissect the case's novel questions, and media outlets, from the Wall Street Journal to CNN, packed the courtroom, sensing a story that could reshape the landscape of legal history. As Tenga delivered his ultimatum, the room crackled with raw anticipation, the air thick with the weight of what was to come. Leavitt knew this wasn't merely about a handful of documents. It was a battle over the Constitution's separation of powers, the limits of judicial authority, and the delicate balance between transparency and privilege in a deeply polarized age. She'd prepared relentlessly, her legal strategy a fortress constructed on the bedrock of precedent and principle. "Your Honor," she began, her voice steady and resonant despite the sword of contempt hanging over her, "I respectfully maintain our objection to producing these specific communications, given their profound constitutional dimensions." Tenga's eyes narrowed, his patience visibly fraying like a taut rope on the verge of snapping. "Ms. Leavitt, let me be crystal clear. This is not a negotiation. Your objections have been ruled meritless by this court." Leavitt stood resolute, her composure an unyielding fortress against the storm. "Your Honor, we firmly believe this dispute raises constitutional questions that warrant further judicial review." Tenga's voice sharpened, an edge of steel cutting through his words. "We've heard your arguments on executive privilege, Ms. Leavitt, and I've ruled unequivocally, the privilege does not extend indefinitely after an administration ends, especially for those in non-senior advisory roles." The government's lead attorney, Sarah Keller, a seasoned Department of Justice veteran with a reputation for tenacity, rose to her feet, her tone dripping with triumph. "Your Honor, we've endured repeated and unjustified delays. These documents are critical to the regulatory issues at hand, and Ms. Leavitt's organization initiated this lawsuit. They cannot challenge the agency's actions while simultaneously withholding relevant discovery." Murmurs swept through the gallery like a gathering storm, reporters scribbling furiously, sensing the confrontation was hurtling toward its climax. Leavitt turned slightly, addressing Keller with a measured glance before returning her focus to Tenga, her voice unwavering. "With respect, Your Honor, The government's characterization grossly oversimplifies the constitutional stakes. The communications they seek involve discussions with former White House counsel about the very regulatory framework we're challenging in this case. Terenga leaned forward, his frustration now a tangible force, his voice booming. Ms. Leavitt, I'm not seeing compliance with a lawful court order, only excuses that border on defiance. Leavitt's response was calm but resolute, her words carrying the weight of conviction. Your Honor, we've submitted a detailed privilege log identifying each document and the basis for our objections. We're not refusing discovery outright. We're safeguarding specific communications that carry profound constitutional protections. Terenga removed his glasses, a gesture that seasoned court observers recognized as a harbinger of his growing impatience. Your privilege log asserts protections I've already deemed inapplicable, Ms. Leavitt. Are you taking the authority of this court seriously? The tension in the room was electric, the gallery hanging on every syllable, the air crackling with the anticipation of a breaking point. Leavitt, undaunted by the mounting pressure, reached into her briefcase with deliberate precision, producing a thin blue folder that seemed to pulse with potential. Your Honor, she said, her voice steady yet infused with quiet urgency, we've identified an additional consideration that we believe demands the court's immediate attention. Terenga sighed heavily, his voice laden with skepticism, his patience stretched to its limit. Unless you're announcing compliance with my discovery order, Ms. Leavitt, I'm uninterested in further delay tactics. Leavitt's response was a beacon of resolve, cutting through the judge's dismissal. This is no delay, Your Honor. We've prepared a supplemental brief addressing a recent Supreme Court decision that is directly and critically relevant to this case. Terenga's expression darkened, his voice a low growl. The time for filing briefs is long past, Ms. Leavitt. This matter has been argued and decided. Keller, sensing an opportunity, interjected with force. Your Honor, this is nothing but another blatant attempt to relitigate settled questions. The courtroom buzzed with restless energy, the stakes escalating with each exchange, but Leavitt pressed forward, her voice rising above the chaos, clear and unyielding. Your Honor, we're not relitigating. We're presenting new authority that emerged after your initial ruling. Authority that reshapes the legal landscape of this dispute. Terenga's skepticism was palpable, his tone sharp and probing. What new authority could possibly justify this? Leavitt's answer struck like a lightning bolt, electrifying the room. The Supreme Court's decision in Department of Commerce versus New York State Archives, issued just 3 days ago, directly addresses the scope of protections for executive communications in a context critical to our case. A ripple of shock swept through the gallery, reporters scrambling to search the case on their phones, the government attorneys visibly rattled by the mention of a ruling so fresh it hadn't yet permeated legal discourse. Keller leapt to her feet, her voice tinged with desperation. Your Honor, we're unfamiliar with this decision's applicability to the matter at hand. Leavitt seized the moment, holding up her blue folder with quiet confidence, her words a clarion call. That's precisely why we've prepared this supplemental brief, Your Honor. The Supreme Court's reasoning clarifies the scope of privilege for former administration officials engaged in policy consultations. Terenga studied Leavitt with a scrutinizing gaze, his voice stern yet tinged with curiosity. Ms. Leavitt, if you're misrepresenting a Supreme Court ruling as a mere delay tactic, the consequences will be severe. Leavitt's response was unshakable, her conviction radiating through the room. I would never do that, Your Honor. The opinion was released on the court's website at 10 a.m. this past Monday. Our brief includes full citations and the most relevant excerpts. Terenga extended his hand, his expression unreadable. Let me see this brief. As Leavitt's colleague swiftly passed the document to the clerk, who delivered it to the bench, the courtroom fell into a tense, expectant hush. Tanga began reading, his face a mask of concentration, occasionally marking the margins with a pen. The government attorneys huddled frantically, pulling up the Supreme Court opinion on a laptop, their whispers urgent and strained. The minutes stretched into an eternity, the room holding its collective breath as Tanga meticulously compared Leavitt's brief to the precedent itself. The air was thick with anticipation. Had Leavitt's bold gamble paid off, or would Tanga dismiss her maneuver as a desperate ploy? The outcome hung in the balance, the weight of constitutional history pressing down on every soul in the chamber. Tanga cleared his throat, shattering the silence, his demeanor subtly transformed from stern enforcer to contemplative jurist. He set down Leavitt's brief and the Supreme Court opinion, his voice measured but infused with a newfound respect that reverberated through the room. "Ms. Leavitt," he began, "this court prides itself on its unwavering commitment to following controlling precedent, no matter when that precedent emerges or how it challenges our prior understanding." He paused, removing his glasses and placing them deliberately on the bench, a gesture that signaled a shift as profound as the ruling itself. The Supreme Court's ruling in Department of Commerce v. New York State Archives does indeed address several issues central to the dispute before us. A murmur of astonishment swept through the gallery, reporters typing with feverish intensity, Keller's team visibly deflated as the tide turned. Tanga lifted Leavitt's brief, his voice steady, but carrying the weight of acknowledgement. On page 4, Ms. Leavitt cites Justice Roberts' majority opinion, which states, and I quote, "The privilege protecting executive communications extends not only to direct presidential advisors, but also to those officials whose consultations continue to inform ongoing policy implementation, even after their formal government service has concluded." He turned to a marked page in the Supreme Court opinion, his tone deliberate. The court further specifies that when former officials continue to advise on the very policies they helped develop, the privilege that attached to those communications during their tenure remains intact, provided the communications directly relate to ongoing policy execution. Leavitt stood motionless, her composure a fortress of professionalism, yet inwardly her heart surged as Tanga not only acknowledged her argument, but quoted directly from the precedent she had so boldly introduced. "Ms. Leavitt," Tanga continued, his gaze settling on her, "your brief makes a compelling and well-reasoned case that at least some of the communications at issue, specifically those with former White House counsel Sam Warrington regarding the regulatory framework your organization is challenging, fall squarely within this newly clarified scope of executive privilege." He turned to Keller, his voice now probing. "Ms. Keller, the court must now reconsider whether the discovery order, as previously framed, remains consistent with this controlling precedent." Keller, scrambling to regain footing, protested weakly, her voice tinged with unease. "Your Honor, even granting this interpretation, surely not all the documents at issue qualify for such protection. The plaintiff should still be required to produce the non-privileged materials." Tanga nodded, his response measured but fair. "That's a valid point, Ms. Keller." He turned back to Leavitt to address her directly, his tone expectant. "Do you, Ms. Leavitt, maintain that all the withheld documents fall within this privilege as articulated by the Supreme Court?" This moment was the moment Leavitt had meticulously prepared for, this pivotal moment, the fulcrum of her strategy. Her voice steady, clear, and resolute, she replied, "No, Your Honor. After conducting a thorough review in light of the Supreme Court's guidance, we believe approximately 62% of the withheld documents fall squarely within the protected category as defined by Department of Commerce. For the court's convenience, we have prepared a revised privilege log that specifically applies the law's criteria to each document." She nodded to her colleague, who rose swiftly and approached the bench with a new document, its pages a testament to her precision. "We're prepared to produce the remaining documents immediately. while maintaining our constitutional objection to disclosing those that meet the Supreme Court's protected standard. Terenga accepted the revised log, studying it with meticulous care, the courtroom silent, save for the soft rustle of pages. Occasionally he nodded, his expression one of measured approval. Finally he looked up, his voice resonant with authority. "Ms. Leavitt, this is precisely the kind of good faith response to new precedent that this court expects from counsel. Your revised privilege log appears to thoughtfully and rigorously apply the Department of Commerce standards." He turned to Keller, his tone firm. "Ms. Keller, the court will need to reevaluate its prior ruling in light of this controlling precedent. The contempt consideration is hereby suspended. Ms. Leavitt will produce the non-privileged documents by noon tomorrow, as previously ordered. The government will have 1 week to respond to the revised privilege assertions based on Department of Commerce." He paused, his gaze settling on Leavitt with an unmistakable glimmer of respect, a rare acknowledgement from a judge known for his stern demeanor. "Ms. Leavitt, I commend your vigilance in monitoring and promptly applying emerging precedent. Too often, attorneys fail to adjust their positions when the legal landscape shifts, but you have demonstrated the diligence this court values." Leavitt nodded respectfully, her voice steady but tinged with gratitude. "Thank you, Your Honor. We take our obligations to this court and to the Constitution with the utmost seriousness." Terenga turned to address the entire courtroom, his voice carrying the weight of a broader truth. "This case illustrates why our legal system demands constant vigilance and adaptation. Supreme Court precedent controls, regardless of when it emerges or how it reshapes our prior understanding." He gathered his papers, signaling the end of the session. "We are adjourned until next Thursday at 10 a.m., when we will address the revised privilege assertions." As Terenga rose and exited the bench, the courtroom erupted in a cacophony of hushed conversations, the tension giving way to a frenetic energy. Reporters surged toward the doors, eager to file their stories about the dramatic reversal that had unfolded in mere minutes. The government attorneys huddled in a corner, their faces etched with concern, their strategy in disarray. Leavitt, ever composed, packed her materials into her briefcase with deliberate care, her calm exterior masking the monumental triumph she had just achieved. In the span of half an hour, she had transformed a dire threat of imprisonment into a resounding legal victory, not through theatrics or defiance, but through meticulous preparation, razor-sharp legal reasoning, and an unerring sense of timing. This was no ordinary win. It was a moment that would reverberate through the annals of constitutional law, a testament to the power of intellect over intimidation. The aftermath was nothing short of a legal and, cultural tsunami, its shockwaves rippling through Washington, legal academia, and the public square. Within hours, legal news websites blazed with headlines. Leavitt escapes contempt. Cites new Supreme Court ruling to stun judge. Terenga backs down after Leavitt's brilliant legal maneuver. Supreme Court precedent saves young lawyer in dramatic courtroom reversal. The footage of Terenga commending Leavitt's legal acumen mere minutes after threatening her with jail became a viral sensation shared across social media platforms, amassing millions of views. The hashtags Charge Leavitt wins and Constitutional Victory trended globally, joined by Char Justice for Privilege and Char Law Over Power, as the public marveled at the clash of courage and intellect. Conservative commentators were electrified, with figures like Ben Shapiro tweeting, "Karoline Leavitt just schooled a federal judge with superior legal knowledge and unyielding principle, a masterclass in fighting judicial tyranny with brains." On Fox News' primetime show, former Judge Andrew Napolitano analyzed the confrontation with fervor. "What we witnessed today was nothing short extraordinary. Leavitt educated the court on a controlling precedent that fundamentally altered the legal landscape. This isn't just a win for her client, it's a seismic development in the law's application of executive privilege to former officials." Even mainstream media outlets couldn't deny the significance of Leavitt's triumph. CNN's Jeffrey Toobin, appearing on Anderson Cooper 360, offered a rare concession. Leavitt's handling of this case was frankly masterful. The government's team was caught flat-footed, and they should have been the first to flag this Supreme Court ruling. Judge Terenga, widely respected but had to adapt, and he did. MSNBC's legal analyst Lisa Rubin offered a measured take. While this outcome may frustrate those advocating for greater transparency from former administration officials, the Department of Commerce ruling introduces a nuanced approach to executive privilege that cannot be easily dismissed. Leavitt's legal acumen was undeniable. The Washington Post published a detailed analysis titled, "How a 3-Day-Old Supreme Court Ruling Reshaped Executive Privilege," hailing Leavitt as a rising star whose quick thinking demonstrated why her legal prowess has made her a force in conservative legal circles. Law schools across the nation swiftly acted to incorporate the Terenga-Leavitt confrontation into their constitutional law curricula, recognizing its pedagogical power. Harvard law professor Noah Feldman wrote in Bloomberg Opinion, "The Terenga confrontation will likely become a staple in law school textbooks, a perfect illustration of how new Supreme Court precedents can immediately reshape ongoing litigation. Leavitt's preparation and precision should be a case study for law students everywhere." For Judge Terenga, the incident sparked both criticism and admiration from observers. Some legal observers faulted his initial rush to contempt, arguing it suggested a premature judgment before fully exploring all relevant precedent. Others, however, lauded his willingness to pivot when presented with undeniable authority, a hallmark of judicial integrity. A former clerk from another federal court, speaking anonymously to an anonymous source at Legal Times, observed, "Judge Terenga showed both the problem and the solution in our system. Judges sometimes rush to judgment, but our system demands correction when precedent speaks." Leavitt's correction was nothing short of brilliant. The Department of Justice Department found itself in an uncomfortable spotlight, with internal sources reporting to Politico that senior officials were reviewing whether their attorneys had dropped the ball by missing the Department of Commerce ruling. A former DOJ official commented to Politico, "This is an embarrassment. The government should have been the first to bring this precedent to the court's attention, not the last to be blindsided by its implications." Leavitt maintained a gracious and measured public stance, issuing a brief statement to the press. The Constitution's separation of powers often raises complex questions about privilege and accountability. I'm profoundly grateful that our legal system ultimately honors precedent over preference. The Liberty Foundation will continue its mission to defend constitutional boundaries against government overreach. Behind closed doors, however, Leavitt's stock in conservative legal circles skyrocketed, her victory a rallying cry for those championing originalism. Within days, she received invitations to speak at the Federalist Society's prestigious annual convention and several top-tier law schools, her name synonymous with legal excellence. The Wall Street Journal's editorial board published a glowing piece titled "Leavitt's Lesson in Constitutional Fortitude," arguing that her unflappable command of constitutional law and serene demeanor under pressure embody the finest traditions of the legal profession. The case continued to unfold, with Leavitt producing the non-privileged documents as promised the next day. The government's response to her revised privilege log was notably conciliatory, conceding that many documents likely fell within the Supreme Court's newly articulated standard. Terenga ultimately upheld privilege claims for 52 of the 60 documents Leavitt identified as protected, cementing the Leavitt application of executive privilege as a recognized legal principle. The broader impact was profound, with legal scholars dubbing the principle the Leavitt application. The notion that former officials retain confidentiality protections when consulting on policies they helped shape. Northwestern University Law School announced a symposium titled The evolution of executive privilege from Nixon to Department of Commerce to Leavitt, drawing leading jurists to debate its implications. For everyday Americans, the confrontation offered a rare, electrifying glimpse into how constitutional principles are tested and refined in real time. A widely shared X post captured it perfectly. Regardless of your politics, watching Leavitt turn a jail threat into a legal triumph with nothing but knowledge and courage is a masterclass in how our system should work. The ripple effects reshaped legal practice. Law firms instituted rigorous training on monitoring new Supreme Court decisions, citing Leavitt's case as a model. Courts nationwide saw a surge in supplemental filings, citing recent precedents, reflecting a more proactive approach to emerging law. The Administrative Office of U.S. Courts issued new guidance, urging judges to inquire about new authority before issuing contempt findings, a direct response to the Terenga Leavitt saga. 6 months later, when Leavitt argued her first case before the First Circuit Court of Appeals, Terenga was in attendance, a gesture widely interpreted as a profound respect for her legal prowess, despite their earlier clash. When asked by a journalist, he offered a rare comment. Good lawyering deserves recognition, especially when it corrects a court's course. The Terenga Leavitt confrontation transcended a mere legal showdown. It became a case study in the triumph of constitutional fidelity, where intellect trumped power and precedent guided justice. Georgetown law professor Neil Cadiel wrote in his influential blog, "The system worked precisely as designed. Leavitt didn't defy the court, she enlightened it. Terenga didn't cling to error, he adapted to truth. That's not failure, it's justice's victory." If this saga of courage, intellect, and constitutional clarity set your heart ablaze, smash that like button, subscribe, and comment. Where's the line between privilege and transparency? Share your stories of truth prevailing against power. Join us for more battles shaping our nation's soul, and let's champion a future where the law endures as our guiding light.